Hello and welcome to today's presentation on POPI by Dealer Financial Services. My name is Geoffrey Forrester, the Compliance Officer for Dealer Financial Services. Dealer Financial Services is a licensed financial service provider and registered compliance practice. We specialize in providing motor dealers in South Africa with a phase compliant platform for the F&I managers to operate on. We also assist motor dealerships with various legislations in keeping them up to date, compliant, and aware of all legislation that they have to comply to. Okay, just a brief overview of what we're going to run through. Firstly, an introduction to the POPI Act, purposes of the Act, some of the definitions, 8 conditions of lawful processing of information, which is accountability, processing limitations, purpose specification, further processing of information limitations, information quality, openness, security safeguards, and finally data subject participation. At the end of that, we're going to go through the dealership to-do list, what the dealership has to do to get registered, make sure everything is right and up and running, and then we'll handle questions and take it from there. Just on that note of questions, before you process, please just email through your questions or type on the section for questions on the presentation, and I'll answer them at the end of the presentation. Hopefully I will cover most of them before we get there, but yeah, I'll go through them all and answer them because I'm sure they're all going to be relevant to everybody else. Right, Protection of Personal Information Act 4 of 2013. As you can see by the date, this is the date that it was actually gazetted. When it commenced was April 2014, so it's been around for 7 odd years. It's nothing new. We've been working with the banks, which have been under the whip of POPI for 7 years. The parts that are affecting the motor industry, though, they became into effect on the 1st of July 2020, but there's a little clause there that says parties have been given 12 months to achieve compliance. So effectively, we have to be compliant by 1 July 2021. And this is going to go through that whole act, and we're available to assist any dealership in becoming compliant and getting all their processing procedures and etc. in place to be compliant with the act before then. So any assistance, please drop us an email. We've got the details. Thanks. Purpose of the POPI Act. POPI Act was introduced to enforce certain conditions and minimum requirements for the processing of personal information. Establishment of an information regulator. So the information regulator, as per the logo you saw on the first page, they have been established, they're up and running. Their primary function is going to be to enforce this act and ensure compliance thereof. They're going to be monitoring, controlling, issuing codes of conduct, etc., which are already available on their website, some of those codes of conduct. They're also there to regulate the flow of personal information, including across borders of the Republic. So it would be your personal information flowing to servers stored in, say, for example, Russia, etc. They'll put processes in place to make sure that that's controlled and how it's run. The data subject, that is the person that's been referred to, in other words, the subject of the information that's being obtained. It can also include a company. So your clients are data subjects, your potential clients are data subjects, applicants, successful or unsuccessful, staff are data, anybody whose information you collect are data subjects. Processing or further processing of information. This is the act of getting the information, it's the retention of the information, it's the access and disclosure, and of course then the final step, the disposal of the information. So as soon as you start collecting information, you are processing, as the act refers to, the processing or further processing of information. Okay, lawful processing of information. Now we dive into what the act is actually all about. If you are going to be processing information, it has to be done lawfully, otherwise it's illegal, I guess. Processing and further processing of personal information is only lawful if it complies with the 8 conditions of processing specified in the POPI Act. So the POPI Act brought out 8 pillars of what makes processing of personal information legal. If you don't fulfill all 8, you're doing it illegally. Okay, so the 8 conditions is accountability, processing limitations, purpose specification, further processing limitations, information quality, openness, security, and data subject participation. So let's go into it one by one. Okay, pillar number 1, accountability. The responsible party must ensure that conditions and all the measures set out in the Act that give effect to such conditions are complied with at all times of determining of purpose and means of the processing. Okay, so what that basically means is every single company, dealership that collects personal information has got a person that is responsible for it. And that person by default is the CEO. The CEO may appoint somebody else to be responsible, and that is what they call an information officer. So your CEO may appoint somebody else to be the information officer. If he does not, he is the information officer by default. You can also appoint a deputy information officer, somebody who can take over in case the current information officer leaves, moves on, whatever the case is. The appointment has to be in writing and it has to be registered on the website. So you have to go to the website, which is, the link is right on the last slide of this presentation, and register whoever your information officer is. Because you're registering somebody as an information officer, it does not say, Mr. CEO, you're hook. You're still going to be responsible at the end of the day. As CEO of your company, you are responsible that your information officer is performing the duties correctly. So you've got to make sure that everything's running smoothly. I suppose that's the job of the CEO. Duties of the information officer. Firstly, develop a compliance framework. So you've got to run through your whole business and look where POPI is going to impact your business. Then you have to develop a framework to make sure that you stay within the boundaries of the law. Then you have to implement that framework, monitor and maintain it. You have to do a personal information impact assessment. What does that mean? Okay, in a nutshell, you have to go through the business and see where this POPI Act is going to impact your business, and then work out ways to make sure that you stay compliant with the Act. Standards exist to comply with the Act. Okay, so you set all the standards, make sure everybody knows what they're doing. That's the next part. Develop a manual to ensure everybody knows what needs to be done, and that information is not kept longer than is necessary, and that only relevant information is kept. Okay, you must have an internal awareness session. So all staff must be trained and made sure that they understand all the different parts of this Act and how it impacts them and what they can do and what they can't do, etc. Because if you haven't trained them and taught them, they can turn around and say it's your fault. Yeah. So train them, make sure they know what's happening. All staff must be aware of the Act and how it's impacted them. You have to keep record of the training, because yeah, you know what staff are like. They're going to turn around and say, you didn't tell me, so it's not my fault. Not quite true. Dealing with requests made by the business in respect of POPI. So the information regulator is going to get a complaint, hypothetically speaking, in the future, saying that one of your clients complained to say the information was leaked to some insurance company who's been phoning them and they didn't authorize it. You are then getting a request to what information you're keeping. You're going to have to deal with the information regulator and give them all the information they want regarding that. Okay, so accountability falls on the CEO at the end of the day, and the CEO may appoint an information officer to assume the responsibilities of implementing the manual, make sure everybody's trained, etc., etc. All right, part 2, processing limitations. Processing, remember, is the using of the information, gathering the information, disposal of the information, all those kind of things. Personal information may only be processed in a fair and lawful manner and only with the consent of the data subject. Must be obtained directly from the data subject. That's quite a big one. It must be obtained directly from the data subject, because we make use of things like banks who use RTC and credit scores and things like that. That's not coming directly from the data subject. That is handled in different parts of the Act, but I'm not going to go into this. if the client is applying for credit, then the credit provider has the right to obtain other information on the client. But if we're processing information, you can't get the application, for example, or OTP filled in by somebody else who's sharing personal information. Like a surprise for my wife, I want to buy it and put everything on my wife's name, use her ID and give it. No, you've got to get it directly from the wife, not me. Okay, so there goes all the surprise presents for motor cars. Data subject must be aware and consent to you gathering and using the information. Kind of ties in with what I just said. So you can't use information unless the data subject consents to it. Another good way of explaining this is when you walk into a dealership, the first thing they do is they ask you to fill in a form which gives your name, ID number, phone number, and your temperature. And this is gathered because they want to inform you if somebody had COVID and you may have been exposed to it. Now, you're giving that information and consenting to them using it for the purpose of calling you if you've been exposed to COVID. They can't use that data for something else like marketing campaigns, etc. It can only be used for what it was given. And the user must consent to that. So if I don't sign that little form to say, phone me if somebody exposed me to COVID, then you can't actually phone me and tell me. If you use a third party to gather information, the data subject must consent to the information being shared with you. Makes sense. You can't use information. And a question popped up on this one. What happens if my company is gathering the information, but we're a subsidiary? We're let's call it company ABC trading as Nissan Drakensberg, and you then want to share that information of that client because he couldn't buy the Nissan, but he also wanted to look at the Mitsubishi at Drakensberg ABC, and you then send it to a CBPTY Limited trading as, because they've got common shareholding, and that's not allowed. You've got to get the client specific permission to share that information. You can't just cross-sell. As soon as your PTY is not the same PTY, you can't use information over that little barrier. It's got to stay within that company and what it was given for. Unless you get the consent of the client, obviously. Only information that is required for the specific purpose for which it is gathered may be stored or used. Again, I'm going to refer to gathered information for POPI for COVID purposes. You can't go using that information for marketing, insurance, or finance, or something to that effect. Number 3, the third pillar, purpose specification. Personal information may only be processed for specific, explicit, defined, and legitimate reasons. The purpose must be documented and adhered to. So when you're collecting the information, for example, on the COVID form, you must document what the information is being used for. The client has got a right to know what it's being used for and why you need it. You can't just gather information and say, we have to have it. You need to be able to tell the client why you're using it. Data subject has the right to know what information you have and for what purpose it was gathered. Once used for the specific purpose, it must be destroyed. So you can't hang on to that information forever and a day, just after a specific period. For example, and I'm going to jump back to the COVID form again because it's so common, is that information we will know those people after, let's say, COVID, I think it's got a 14-week incubation period, so after 14 weeks, you should legitimately destroy the information. You're not going to use it. You're not going to phone anybody because, they wouldn't have been exposed to anybody with COVID after 14 days. Don't quote me. I'm not a doctor, please. I don't know what the incubation periods are. All that kind of stuff. You'll be required to account for what information you hold, for what purpose it was gathered, and the date the information must be destroyed. This refers back to the information officer is going to be responsible to the information regulator. The information regulator at any time can come to your business and say, what information do you hold of, what personal information do you hold of your consumers, your clients, and these are the questions they're going to ask you. The date information must be destroyed, information you hold, and the purpose. Okay, the process of destruction of the personal information must prevent its reconstruction. So when you destroy the information, make sure you can't sellotape it together or download it again or clean the disk and reuse it, whatever the case may be. It must be destroyed, gone. Further processing limitations. Personal information may not be processed for a secondary purpose unless the process is compatible with the original purpose. That's a biggie there. That's huge in this motor industry we work with. Compatible with the original purpose. And I'm going to elaborate on that a little bit here. Okay, so you gather information, you do a whole transaction, you tell the client, I'm using your information for invoicing the transaction, sending your application to the bank, you did make all the disclosures, client's happy, drives away, he's got his car, he's happy. His car is due for a service in 6 months' time, and you've got a CRM process that works in your business where you phone him and say, dear client, your car is due for a 6-month service. Will you be bringing it in because you want to boost your workshop sales? That needs to be disclosed to the client up front to start with, but it is compatible with the original purpose. The original purpose is to provide the client with a car and maintain and keep him happy with his car, and for that he needs to service the vehicle, and a reminder call, I would say, is compatible with that purpose. If your client turns around and says, please just take my records off, then take his records off and don't phone him again, because he may want to service somewhere else. You never know. But it is compatible. If he complains, you have to remove his name from your database. Data subject has to be aware of the purpose and period you will use the information. Like I said, he must know that you're going to be phoning him and advising him about his services, etc., etc. What you cannot do is, for example, your salesman takes the application, does the transaction, but he's got a friend who works at an insurance company and he wants to send the data there so that the insurance they can write the client's insurance policy. And maybe pay him a little kickback in the process, or maybe on behalf of the dealership, same things apply. If you don't have the client's permission to share the information with that person specifically, then you can't forward the lead. So you have to have the client's permission before the lead is sent, and the client needs to know who's sending it, why they're sending it, how long they're going to be keeping the information. So if you forward that information, there's a whole string of responsibilities that now fall on your shoulders. So make sure your service level agreements are in place, especially on the likes of Signia and Ceriti, and your application processing forms, that you have the client's permission before you tick that forward lead to insurance companies. Okay. Please forward questions. I'm not going to answer questions as we go. I'll get to it at the end. I'll answer all the questions and go through it right at the end, just to get through this as quick as possible. Thank you. Right, information quality. The responsible party must take reasonable steps to ensure that the personal information collected is complete, accurate, not misleading, and up to date where necessary. So you can't go pulling old files and processing them. That would be old. The client might not work there anymore. So if you're going to be reapplying, redo the application. Don't start with an old application. Run through the whole process again with the client. Information directory on data source, we've been through that. Where possible, it's advisable to validate the personal information as it is being captured. So again, if you're doing it manually, asking the client directly from the source, it's probably going to be correct. Data subjects must be advised on how they can update or withdraw consent for the use of the information. So you gather his information, you store it, you do the transaction, you keep his information for your workshop CRM system. The client needs to know who to speak to update that information. Might change his cell phone, his email, his car. Yeah, he might want to have his details removed or updated. So he needs to know who to contact to do that. And that must be, I would say, your information officer details must be printed on your offer to purchase or your invoices or one of the documents the clients will get. Record of advice, also a good place to do it. Openness. The data subject whose information you are collecting must be aware that you are collecting such personal information and for what purpose the information may be used. So again, refer to that COVID form that's being filled in. Don't be sneaky and try and use that for that information for purposes that it was not intended for. Proof of consent is essential. This is crucial. Don't process an application that has not been signed. If a client is not presenting it and giving the application directly to you, don't process the application unless you've got his consent. I know the Signio Ceriti, the application platform companies, are updating systems to make sure that there is consent on applications pre that application go to the bank. So yeah, that will be in place by 1 July. So I've been assured. If not, print, sign. Make sure you've got the client's signature on there. Make sure you've got his consent to share it with every single company you're sharing it. So if you're ticking ABSA, Westbank, Standard Bank, MFC, all the different finance market, don't leave anybody out, but all the finance companies, make sure you have that client's consent to send that information to all of them, not just one. He may think he's applying to his own bank, and next thing he's got an application that's gone through Volkswagen Financial Services, and he didn't consent to that because he wanted to deal with ABSA or whoever his bank was. And yeah, it's going to come back at you. Why did you send this information to the wrong place to start with? Yeah, and you'll have an argument there. Proof that the data subject was informed of how the data will be used and for how long. So again, he needs to sign some document to say you're going to keep that information, how long you're going to keep it, and what it's going to be used for. The data subject must be given the contact details of the responsible person in the organization. So again, your information officer's details must be on a document that is presented to the client every time. The data subject must be advised of his or her rights to complain to the information regulator in respect to misuse of the data. So if he starts getting phone calls, and a classic example, if he gets a phone call from the manufacturer of the car to say what was the service like and rate the service, CSI reporting, we all know about that. If the client didn't give his consent, yeah, that CSI needs to come to an end. The client has to consent to it before it's done. So make sure that document is signed properly beforehand. I do believe it's written into the manuals of the car, the service books, etc. So make sure they sign that documentation and make sure you've got a copy of it so that if you have to prove it, you can prove it. It's pointless giving him the only copy you've got. Okay, and then of course the client has to have the right to access the information, and he has to know where and how to access that information. Security safeguards. This is where it all goes a bit pear-shaped in today's world of cyber hacking and people stealing information. Personal information must be kept secure against the risk of loss, unlawful access, interference, modification, unauthorized destruction, and disclosure. So you can't go sharing people's email addresses with people who make a fraud against them. You'll end up being responsible for sharing that email address. The safety and security risk assessment is required. So every dealership must run through their whole process and see where security is an issue. And this doesn't have to be high tech. I mean, it's pretty obvious we have to have security on our IT systems. Where we load information, where we store information must be secure. But it can come all the way down to low tech. There's little blue and pink and yellow folders lying on salesman's desk that have copies of IDs, drivers, proof of address, application forms, all those kind of that information. It's all personal information. As soon as you write the client's name down, it's personal information. So if you've got data lying on your desk in the form of a file, it has to be secure. So it needs to go into a locked drawer, locked office, locked safe, anything to that effect. Personal information has been stolen from dealerships. It is used to clone applications for finance. It's dangerous information. It can be used and is used very regularly. Cape Town recently had a dealership that the personal information was copied by the person doing the licensing and registration for a dealership. The little blue forms with IDs, drivers, invoice, proof of residence, type of car, who the finance company was. All that information is stored in that little blue form where you do the license and registrations. That information was copied and given to a syndicate who was cloning that information, and yeah, some of the clients of that dealership bought a second vehicle. It got to there were 3 clients whose information was cloned, and they ended up buying a second vehicle. That dealership had to put the clients back in the position they were in beforehand, because they shared the information with the person doing the license and registration without the consent of the client. If you're using a third party to do your license and registration, make sure you have it in writing that the client was informed that you're using a third party, and that he gives permission for you to give that information to the third party for the license and registration. Be careful, safeguard, don't leave information lying around. It's valuable to the criminals that pay for it, so they are going to start stealing it off your desk. Don't leave it there. Policies and procedures must be restrict access to ensure security. So you must ensure that not just anybody can walk in and pull a file out of archives and copy information. Your staff members must be aware that they can't. Somebody must be responsible to keep the stuff under lock and key. It's your client base, it's your dealership, it's your customers' information. Keep it safe. You can't trust everybody who works for you. So put processes in place to ensure that the information is kept safe. The process that people must follow for getting data, for opening something that is archives, must be documented. The information officer must keep it, the process documented, and people must know how to get it, and people must sign it in and out. It needs to be done properly. Data subject participation. Again, this is pretty easy and pretty obvious. We have to allow our clients to be able to update information. You sell a client a motor vehicle and he changes his address, he changes his work, he changes his email address, any of that stuff, he needs to be able to contact the dealership and say, please update my information and forward my notifications to this address. It's assuming he wants it done. So he needs to be able to participate with that information and update it. Okay, dealership's role, what the dealership has to do to be compliant with this act and get in process before the end of the month. The first thing is the dealership has to appoint an information officer. The information officer can be appointed, must be registered at this address. You go to this address, it's going to give you a link that you click on where you can register the information officer. That site is very slow. Be patient. Maybe log in after hours when it's not so busy. I can only assume there's too many people working on it at the moment while it's going so slowly, but it is slow. So just be patient and keep trying, and maybe try after hours. It might be a bit better. If you don't get it right, remember the CEO is already the information officer, so don't panic if the CEO is going to be the registered information officer anyway. So it's not a crisis. It's only if you're changing who the information officer is and it's not the CEO that you need to worry, and get this done quickly. Okay, first, once you've appointed the information officer, you register the information officer. Then the information officer needs to know what they're doing and what process they need to be placed, and they need to get some training. So make sure the information officer knows what's happening. There's not a lot of training out there, and I don't think it's a really complicated process. I feel that most dealerships should be able to start implementing processes just based on the information we give them. I don't think a specific training manual needs to go out for information officers, but the information officer does have to implement processes for the dealership to follow, because everybody in the dealership needs to know what to do regarding this act. So once you have an information officer, make sure he knows what to do. Then the information officer must make sure all the staff know what's happening and what needs to happen with POPI, and make sure that staff are trained correctly. So keep record of all training done. This video could act as your training manual to start with until you implement something else. I'm going to be sending the link out. Please use it. It's not confidential information. Anybody and everybody can use the information if you've got the link. That's first part. The keeping record of training done. If you are a dealer financial services client, you just get in contact with your key individual, any one of them, and ask them for your dealership's code, and they will send you a code and a web address. All staff that do the presentation can then go and write a test on the presentation. That will keep their information with us. The staff member will get a certificate to say he's done it. You will get an update of which staff members have done the training, should I say, done the test. And with that comes a certificate to say they accept that they have been trained on it, they accept the process that have been put in place, and they accept that their information as a staff member is going to be used for the things like SARS, BEE, whoever you share their information with. And they can get a detailed list of who you share that information with from you. Okay, so yeah, they are going to be aware of it. They also need to be aware that they cannot download their customer base because they're a salesman and now they're moving to another dealership and they think all those clients are their clients and they have a right to phone them. No, they don't have a right to phone them. The information belongs to the dealership because that's what it was given for. It wasn't given for the personal use of the salesman, it was given for the use of the dealership, so they can't download information. They need to know that, staff members need to know that if they do download it or do take personal information with, they're actually breaking the law and can be charged accordingly. So this act has seriously diminished the value of a salesman in many ways because they can't run around with a database in their phone anymore. They've got to delete that information by law. And if they breach that and you can prove it and they move to another dealership and take your client base with them, you can charge them criminally for breaking the law. So yeah, I don't think salesmen will do that anymore. If they do try it, it's only going to take 1 or 2 criminal charges laid against them and they'll soon stop it. So yeah, your database is now secure. So the act does have some benefits for dealerships, but be wary. And be wary about phoning your sales. You're getting a new salesperson, employing a new salesperson. When you phone for references, the person sharing that information it's personal information, so be careful what you share about staff members who are leaving you. You have to have their permission before you can give that personal information out. Right. Functionality, describe the processing of personal information, collection, use, and destruction. So you've got to put a functional process in place as the information officer and say, where are we collecting information, where are we storing the information, where are we using the information, and how are we destroying the information. List it, make sure that process is foolproof. For example, your OTPs, are they shredded afterwards, or do you store them in a safe place if you need that signature for purposes and you're not loading it electronically? Make sure that paper is kept safe. Make sure that access to that information is limited and people are accountable for who got the information, where is it gone, etc., etc. The reasons you are going to be collecting information: customer invoicing, marketing, finance application, licensing, registering, tax laws, auditing. Those are all the reasons why you need to keep the information and who's going to have access to that information. Make sure you've got the right service level agreements in place, that nobody's going to use that personal information for reasons that you're not meant to. List the storage facilities, your safe in the back where you keep all the files, phones, computers, servers, cupboards, etc., etc. Make sure those storage facilities are safe and cannot easily be broken into and stolen. List the individuals who have access to that information. Make sure that they are accountable, and if they've taken it, you will know who has taken it. In other words, the person who logs in must have a password and nobody must be able to use that password, only them. So if the information is stolen while they were logged in, then they stole it. Ensure data subjects agree to the collection, use, and storage. So make sure you have customers' permission where they sign to say that the information can be used. OTPs must be updated, etc. Finance applications must be updated. Perform an impact study on personal information data. Information officer must manage the risk. So the information officer must just go through the whole process and see where the risks are, what risks, how they can mitigate, store stuff electronically instead of in files and safes, etc., etc. Update all contacts including employee contacts. So get all the right information, make sure information is correct. If you have a database and CRM system you're already using, a good idea would be to send a blanket email to everybody and update the information, and at the same time request permissions for the use of that information. Here's the big one: establish a privacy policy and procedures manual. We have written a standard privacy policy, POPI policy procedures manual for dealerships. Drop your key individual an email. They will then forward it to you. You can just replace it and run through it and then modify it and change it as per your dealership's needs. It covers pretty much everything. If you think we've missed something else, please update us. We know the motor industry, it's primary source of our business. We don't operate anywhere else. It's just the motor industry we operate, so we understand it pretty well. But there is a very good chance we've left something out. So if you pick up something, please email it and we'll add it in. Or add it in yourself. It is a Word document that will be sent to you. It's your policy and procedures. We're just giving you a template to work from. And that's our presentation. Let's go on to the last section, which is questions. Any questions out there? Right, question 1. We use a third party to do license and registration. Okay, I did handle that a bit earlier. Make sure that third party is using information, that you get the client to specifically sign a document to say they're happy with it. I think it's called a proxy letter that they have to sign, where they say, please authorize Joe to register the vehicle on my behalf, or license the vehicle on our behalf, and make sure that they sign the actual blue paper. Don't sign it on their behalf. Don't commit fraud. It's not legal. Yeah, that's a tricky one, because nobody wants to go and stand in those queues. But yeah, get the permissions. It's important. Question 2, calling clients to have their car serviced. Okay, we've run through that a bit. You need to make sure that you have the client's permission to do so. It is relevant to the vehicle, the sale of the original intention of the sale is to provide the client with good service for his motor car. So it's not unusual. He should be happy to get that phone call to say, please come service your motor car. If he doesn't and he's not, and he requests you delete his details, make sure you do. Don't phone him again, because then he's going to have a problem, and he can address it with the information regulator. Yeah, I would suggest you add that to your offer to purchase, especially with new cars. Add the little tick box, please phone me for services, etc., etc. And make sure the client has the right to opt out any stage. If you're using emails, make sure that emails have the opt out option at the bottom. We use Pinnacle. How will data be removed and when? Okay, again, this is Pinnacle. That's a CRM/OTP system. I think, I'm not that sure. If you're using one of these systems and they're keeping information, make sure that the SLA is in place and that they're not going to use the information for any other purpose that you're sharing it with them. And make sure that they have a process in place where you can select when and where that data is deleted and it complies with everything we've just discussed. So it's your responsibility to make sure that the third parties that you use, that you have the correct SLAs in place and that they comply with your policies and procedures that you put through. And that goes for accounting systems as well. If you've got an online accounting system, make sure that information is secure and responsible, kept safe. You can't store it in databases that are in some countries. Don't know which ones they are, but you know that information is going to come from the information regulator. Make sure the data is stored in the right place. Are we allowed to get referrals? If you're getting a referral from a friend of yours, for example, you're at a braai and Johnny says, hey, Jane wants to buy a new car, please give her a call. By all means, go give her a call and say, hey, John gave me your number because he said you're interested in buying a motor car. Just know that that client has the right to say, no, I'm not buying a motor car, please don't call me again, and then don't call them again. Don't go saving the details. And if she's got a problem with John sharing it, then her information, then she must take it up with John. But as long as you keep that civil, there shouldn't be a problem with it. Don't be abusive by phoning the person continuously when they said no, thank you. Consent to referral. Okay, making referrals. This goes a little bit further. If you're referring one of your clients for example, to an insurance company, you need to make sure that that client consented to the referral. And this goes right the way through to even the finance application. You need to make sure that the finance application, the client consented to you sending it to all 5 banks, if that's the case, where he wanted it sent to all 5 banks. Remember, all 5 banks are going to go through his personal information. He needs to know that that information is going to stay on their databases as well. It's also going to reflect on ITC, etc. So you need to make sure he's aware of that. So don't send information to people unless the client said, yes, you may send my information to that person. If the client said, send my information to an insurance company, make sure he's aware that that insurance company's brokerage is going to share it with umpteen different insurance companies. So if you're sending the lead to a broker, the broker is going to share that same information with 5 or 6 different insurance companies. If he doesn't give consent, don't do it. You're breaking the law. You will be susceptible to some kind of fine and some scrutiny from the information regulator. Keep those leads closed. Make sure it's only done through legitimate channels. Don't do it from the salesman's desk. Surprise purchase of a vehicle. Yeah, that's something of the past. The person buying the vehicle, and this crosses over with FICA as well. So, surprise purchase, be suspicious. Nobody buys a car by surprise anymore, and if they do, be very suspicious and treat it very carefully. Can we share information between in our group? Information is being shared within a group of companies. As soon as the simple rule here is that as soon as the CK number of that company is different, then it's a different company, regardless of who the shareholders of the company are. So no, you can't share it unless you specifically get the client's permission to share it with subsidiaries or different companies. Then you need to, again, be very specific. It needs to say on that sheet, we are working for ABC, which is a holding company of DCY, PTY, blah, 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 and that we will share the information with all 4 of these different companies or 5 of these companies, but they must be listed, and it needs to be specific where you can go back when the client argues and says, why did you send my information to the company? We say, here, you specifically gave us permission to share that information with the company. If you can't prove that you had specific consent from the consumer to share that information, don't share that information. If it's a different PDY, it's a different company. You can't share the information. The salesman keeps a list of the clients he deals with on his personal laptop. Can we use this if we change companies? Okay, sorry, whispering here. Salesman keeps a list of clients he deals with on his personal laptop. Can we use it if we change companies? Okay, we've been through this. The information given to the salesman is given to him as an employee of that company. It's not given to him personally. It's given to him as an employee of the company. It's not his information. The client is not sharing their personal information with that specific salesman. Yes, that salesman must service the client and perform functions on behalf of the company he's employed with, but it doesn't belong to him. He is only doing the job on behalf of the company that employed him. So no, he cannot store that information on his personal laptop. There, he's already processing personal information without consent. So he'll be breach of his breach of this act, and I'm certainly sure he'll be breach of his employment conditions. So no, salespeople, you cannot store customers' details on your personal devices. That includes phones, unless you have specific consent from the company you work for to do it and consent from the client to do so. So be very careful that as soon as you break the law here as a salesman, you're opening yourself up to criminal charges. It's a lot easier now for a dealership to say, hey, salesman Peter stole all our personal information, and go lay a criminal charge against you, because now you've broken the law. They don't have to prove damages anymore. This is serious. Salesmen, do not take personal information with you. It's going to land you in hot water. Don't do it. Not worth it. Get the new company to generate your database for you. Okay, that pretty much handles it. I'm going to cut it there short. Thank you very much for watching. Really appreciate it. Hope this helped.